Members, House will be back in session.
So, members, we do have business on the daily file that is eligible to take up. We have members on the floor that are prepared to present their bills. We were going to continue with Senate third reading. No, with concurrence items. We'll begin with concurrence items. Mr. Blakesley is prepared to take up file item 11. Clerk will read.
Assembly Bill 43 by Assemblymember Blakesley, an act relating to the California Earthquake Authority.
You may open, Mr. Blakesley.
Thank you, Madam Speaker, members. AB 43 is back for concurrence with technical amendments from the Senate. This bill will make the California Earthquake Authority more effective while cutting expenses. AB 43 would create a Chief Mitigation Officer position, which develops major statewide programs for California disaster preparedness and seismic home mitigation. Additionally, the bill would remove a 25-employee cap, but does not remove the administrative financing cap, which is at 33%. I'm sorry, it's at 3% of premiums collected. Therefore, this bill has no direct fiscal effect. Instead, this bill saves the CEA money in the long run. With the overall expense cap firmly in place, lifting the employee cap boosts productivity, and a chief mitigation officer is essential to the CEA's major mitigation initiatives. I ask for your aye vote in concurrence with Senate amendments.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote.
So I can take up item 141.
All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 42, noes 0. Senate amendments are concurred in. Members, we are once again going through the concurrence files. There are eligible bills. Please be at your desk prepared to take them up.
The next one we're aware of is Flores 31.
What file? Mr. Blakesley is prepared to take up file item 49. Clerk will read.
Assembly Bill 1351 by Assemblymember Blakesley, an act relating to energy.
You may open, Mr. Blakesley.
Thank you, Madam Speaker. Members, AB 1351 is a cleanup bill to my previous legislation, which allows incremental generation that results from energy efficiency improvements at hydroelectric facilities to be counted as RPS eligible. That bill specifies that the Clean Water Act certification came from the California Water Resources Control Board. AB 1351 allows multi-jurisdictional utilities that serve California customers to count efficiency improvements at existing out-of-state facilities by clarifying that the certification would come from the appropriate border agency in the state that is designated by the Federal Clean Water Act. Senate amendments are technical. This bill has received no votes.
Mr. Huffman.
A question to the author, Madam Speaker.
Without objection.
Mr. Blakesley, would it be helpful to our ability to vote on this bill and the many additional bills we need to vote on today if everyone would please come to the floor so we could vote?
Thank you for that question. In fact, it would expedite the process significantly, as rather than having the roll open for many minutes and potentially having this piece of vital legislation go on call, we could dispose of the matter quickly and promptly and ensure we move through the file in an orderly and efficient manner.
Thank you. I request an aye vote.
Seeing no further discussion, Mr. Blakesley, you may close.
I ask for your concurrence in Senate amendments.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 47, noes 0. Senate amendments are concurred in. Mr. Blakesley is prepared to take up file item 56. Clerk will read.
Assembly Bill 45 by Assemblymember Blakesley, an act relating to land use.
You may open, Mr. Blakesley.
Thank you, Madam Speaker. Members, it is my pleasure to present to you AB 45, which removes barriers to the installation of clean, renewable, small wind resources in rural areas. The bill allows any county to retain an existing wind ordinance or adopt one by January 1st, 2011. If there is not a county ordinance adopted by that date, AB 45 ensures that a property owner is not unreasonably restricted from installing a system that meets the specifications in the bill. Language has been carefully drafted and clarified in the Senate with stakeholders, including cities, counties, and environmental communities. AB 45 has broad support on both sides of the aisle and no opposition. I respectfully ask for your aye vote.
Mr. Nilo.
I have a question of the author.
Without objection.
Mr. Blakesley, this is the third bill in a row that you've presented. Are you not a Republican anymore? I request an aye vote.
Do you have a response, Mr. Blakesley? We can move on. Ms. Yamada has a question or a comment.
Actually, on my own time, Madam Speaker, in response to that question asked of my colleague, we'd be always happy to re-register you at any time. Thank you. Request an aye vote.
Seeing no further debate or discussion, Mr. Blakesley, you may close.
Thank you, members, for your provocative and thought-stimulating questions. These are bipartisan proposals and bills before the legislature that I believe Republicans and Democrats can endorse wholeheartedly. I ask for your concurrence with Senate amendments.
Very well. Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 52, noes 0. Senate amendments are concurred in. We'll move to file item 31. Ms. Torres. Clerk will read.
Assembly Bill 423 by Assemblymember Torres, an act relating to emergency telephone systems.
You may open, Ms. Torres.
Thank you, Madam Speaker and members. The 911 system is in California stands in need of improvement. Assembly Bill 423 addresses one important dimension of the 911 system, training and recruitment of 911 dispatchers. The dispatcher occupation is a high-stress job with a lot of turnover and retention issues. As technology evolves and as public expectations about emergency response change and become more insistent, the job of a dispatcher also changes. Assembly Bill 423 uses the existing structure of the 911 Advisory Board, which advises the state's Chief Information Officer to provide focus for training and recruitment issues. Assembly Bill 423 adds the Post Commission and the State Fire Marshal to the Advisory Board and directs the Advisory Board to provide input to the OCIO on recruitment and training issues, including specifically standardization of recruitment and training of multilingual dispatchers. It does not provide for any specific training or recruitment mandate. The bill puts the relevant interests and experts in the same room to discuss potential improvements to the 911 system. I ask for your aye vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 44, noes 1. Senate amendments are concurred in. We will go to file item 13 by Ms. Evans. Clerk will read.
Assembly Bill 94 by Assemblymember Evans and others, an act relating to conservation.
You may open, Ms. Evans.
Thank you, Madam Speaker. Members, this bill reinstates for 5 years a voluntary Natural Heritage Preservation Tax Credit Program. Senate amendments reduce the extension from 10 years to 5 years. The program is a win for everyone. I respectfully request an aye vote on concurrence in the Senate amendments.
Seeing no discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 44, noes 3. Senate amendments are concurred in. We move to file item 14 by Ms. Evans. Clerk will read.
Assembly Bill 131 by Assemblymember Evans, an act relating to juvenile court cost.
You may open, Ms. Evans.
Thank you, Madam Speaker. Members, AB 131 allows courts to recover the costs of legal representation in dependency cases. State amendments address chaptering out issues with another bill. There's no opposition to the bill, and I respectfully ask for your aye vote in concurrence with Senate amendments.
Seeing no discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 50, noes 4. Senate amendments are concurred in. We'll move to file item 58, also by Ms. Evans. Just one moment. Mr. Torrico, for what purpose?
Thank you, Madam Speaker. Health Committee to meet in the Rules Committee room. Health Committee to meet in the Rules Committee room immediately.
Now we may open on file item 58. Clerk will read.
Assembly Bill 154 by Assemblymember Evans, an act relating to adoption assistance.
You may open, Ms. Evans.
Thank you, Madam Speaker. AB 154 implements federal provisions in the Fostering Connections to Success and Increasing Adoptions Act of 2008. Senate amendments avoid chaptering out issues. There's no opposition again to this bill, and I respectfully ask for your aye vote on concurrence.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 58, noes 0. Senate amendments are concurred in. We'll go to Mr. Fuentes. File item 38. Clerk will read.
Assembly Bill 807 by Assemblymember Fuentes, an act relating to restitution centers.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. Assembly Bill 807 does two things. It requires the California Department on Corrections and Rehabilitation to reopen 2 restitution centers no later than 2010-11 fiscal year, and it modifies eligibility criteria to ensure that all beds are full with appropriate inmates. Amendments taken in the Senate take into consideration the substantial budget cuts that the CDCR has sustained and make the reopening of the 2 restitution centers conditioned on the Secretary of CDCR determining that there is sufficient and appropriate and eligible population. I respectfully ask for an aye vote.
Seeing no discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 57, noes 0. Senate amendments are concurred in. We'll go now to file item 59. Mr. Liu's prepared to take that up. Clerk will read.
Assembly Bill 166 by Assemblymember Liu and others, an act relating to vessels.
You may open, Mr. Liu.
Thank you, Madam Speaker and members. This bill creates a vessel turn-in program whereby the owner of a vessel could voluntarily turn in a boat to a local agency rather than abandoning the boat, and increases the minimum fine from $500 to $1,000 for abandoning dilapidated boats in a waterway. The Senate amendments, which were requested by the Department of Boating and Waterways, will help ensure the agency in gathering data on the number of boats that are surrendered for disposal. The bill was co-sponsored by numerous organizations, including the California Sheriff's Association, and it has no opposition and respect the request, and I vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 55, noes 0. Senate amendments are concurred in. Mr. Miller is prepared to take up file item 77. Clerk will read.
Assembly Bill 1385 by Assemblymember Miller, an act relating to vehicles.
Mr. Miller, you may open.
Thank you, Madam Speaker. Currently, local arson investigators are prohibited from using blue lights on their vehicles, designating them to the public as law enforcement agents. However, these particular arson investigators are designated and trained as peace officers, and their primary mission is defined in code as the detection and apprehension of persons who have violated any fire law or committed insurance fraud. These arson investigators often go on joint missions with local sheriff's deputies and police to apprehend arsonists and other criminals. They make arrests and engage in car chases. They are law enforcement in every typical sense of the word. There are many such investigators in Los Angeles, the source of this bill. These amendments are the result of working with CHP. They are technical and clarifying in nature, further reducing the type of arson investigators eligible to use these lights and specifically prohibiting non-peace officers, as defined by the bill, from using these lights. The bill is sponsored by the California State Firefighters Association and is supported by California Professional Firefighters, and the California Conference of Arson Investigators has received no votes to date, and I respectfully ask for your aye vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 60, noes 0. Senate amendments are concurred in. Mr. Torrico.
I was just ready to prepare on
You're
the speaker's
presenting
bill.
file 78? Mr. Torrico is prepared to take up file item 78 for Speaker Bass. Clerk will read.
Assembly Bill 1394 by Assemblymember Bass, an act relating to workforce investment.
You may open, Mr. Torrico.
Thank you, Madam Speaker. I'm honored to take up AB 1394 for the Speaker. It establishes additional responsibilities for the Green Collar Jobs Council and creates a mechanism for the receipt of funds from state and federal entities and other sources. Senate amendments add the Department of Industrial Relations and other technical amendments. Respectfully ask for an aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 54, noes 0. Senate amendments are concurred in. Members will go back in the file and take up file item 2 by Mr. Fuentes. Clerk will read.
Assembly Bill 335 by Assemblymember Fuentes, an act relating to employment.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. Assembly Bill 335 is a bill that would limit the ability of out-of-state employers to use choice of law and choice of forum clauses that would have the effect of depriving Californian workers of the protection of California labor laws. We took amendments in the Senate that would create a rebuttable presumption that choice of law and choice of forum clauses are void because they are against the public policy of the state. These amendments clarify that in certain circumstances, employers and employees may bargain for these types of clauses. These amendments also give greater discretion while still providing guidance to the courts when deciding whether or not to uphold these clauses. I respectfully ask for an aye vote on these.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. 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 Mr. Fuentes moves a call. We'll move to file item 5 by Mr. Fuentes. Clerk will read.
Assembly Bill 805 by Assemblymember Fuentes, an act relating to vehicles.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. Assembly Bill 805 ensures that an applicant for an auto dismantler's license is complying with important environmental protection and tax payment provisions. AB 805 does not add any additional licensing requirements, but simply asks the Department of Motor Vehicles to investigate all the information submitted on a dismantler's license application to ensure conformity with other provisions of law. We took amendments in the Senate that would simply delay implementation of this bill for licensing renewals. This bill is coming back to us from the Senate floor with no votes. I respectfully ask for your aye vote on the concurrence of these amendments.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 58, no 0. Senate amendments are concurred in. We'll continue with file item 6 by Mr. Fuentes. Clerk will read.
Assembly Bill 14 by Assemblymember Fuentes, an act relating to vehicles.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. AB 14 addresses the O'Connell v. City of Stockton decision in which the California Supreme Court held that local governments lacked authority to adopt forfeiture and impound ordinances as a means of nuisance abatement. This bill expressly grants this authority under specified guidelines. Amendments taken in the Senate clarify that the impoundment period can be any length of time up to 30 days. It also adds a requirement that a qualifying prior conviction must be sustained within 3 years of the arrest for which the impoundment is sought, and other minor technical and clarifying amendments. This bill is supported by a long list of local governments and law enforcement. It's enjoyed bipartisan support, and I respectfully ask for your aye vote, members.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 60, no 0. Senate amendments are concurred in. We'll move to file item 65. Mr. Fuentes, clerk will read.
Assembly Bill 395 by Assemblymember Fuentes, an act relating to employment.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. This bill will allow the Department of Industrial Relations to authorize specific labor compliance programs to enforce prevailing wage laws and other requirements that apply to apprenticeships on public works projects. Amendments taken in
Mr.
this.
Fuentes, one moment. It turns out that this bill does not have, it did not fulfill the one-day file notice period, so it's not eligible to take up today. One moment, let me look at what others are eligible for you to take up. Mr. Fuentes, you are able to take up file item 126. For Senator Leno, that's Senate third reading. You're prepared to take that one up? Clerk will read.
Senate Bill 802 by Senator Leno, an act relating to works of improvement.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. Senate Bill 802 is a pro-business measure to help small California contractors compete on public works projects. This bill caps at 5% the amount that a public entity may withhold in payment due to contractors on public works contracts. Existing law requires that not less than 5% of the total payment for labor and materials be withheld from a contractor until completion of the entire project. This payment policy unnecessarily disadvantages small contractors who simply cannot afford to tie up their own capital or bear the additional loan costs associated with bidding on these projects. This bill also allows progress payments to be paid to subcontractors in a more timely manner and, in return, ensures that general contractors receive sufficient notice when a notice to surety has been issued. This is not a new idea. The federal government has moved to a 0% retention policy for public works, and 20 other states have set their retention caps at 5% or lower. The bill now includes a 2014 sunset. This bill has received strong bipartisan support and passed unanimously off the Senate floor. I respectfully ask for your aye vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 56, noes 0. Senate amendments are concurred in. Finally, Mr. Fuentes, you have file item 147. Clerk will read.
Senate Bill 702 by Senator DeSonia, an act relating to child daycare and making appropriation therefore.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. This bill requires that employees who work in short-term or ancillary child care facilities be on the state's trust line registry, which requires a criminal background check. Specifically, this bill defines an ancillary child care facility as athletic clubs, grocery stores, or any business that provides child care that is secondary to its principal business activity. In order to address concerns raised by the businesses, we have amended this bill to allow for a 12-month phase-in, ensuring that businesses have adequate time to get all of these employees into the trust line registry. Over the years, a number of non-licensed child care facilities that provide short-term child care have popped up everywhere, from the local health club to IKEA and the grocery store, and California law has not been updated to reflect this change and protect California's children. Requiring the employees of these facilities to be in the trust line registry will help to ensure the safety of California's most vulnerable population, our children. This bill has received bipartisan support, has passed out of policy committee with unanimous support. I respectfully ask for an aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 41, noes 9. Senate amendments are concurred in. We'll go to file item 106 for Assembly third reading by Mr. Torlakson. Clerk will read.
Assembly Concurrent Resolution 88 by Assemblymember Torlakson relative to education.
You may open, Mr. Torlakson.
Thank you, Madam Speaker. Members, this has to do with science, technology, engineering, and math, a task force that would look at where we are in California and actually how far we've fallen, how far behind we've gotten. We need these skills developed. We need the curriculum. We need the teachers. We need the focus on this area, which is huge in terms of the needs of the new economy. 15 of the 20 fastest growing occupations in the next 10 years are going to be in the STEM area and will require math and science. Our career technical education programs that we'd like to implement on our schools and prepare young people for the 21st century global economy, they need a foundation, so many of them, in math and science. So this task force would help us by examining where we're at, what we should do about it. There are no state funds involved. It is a bipartisan effort. I urge an aye vote.
Seeing no debate or discussion, clerk will open the roll. Oh, one moment, members. Please strike the roll. This is a resolution. You wanted to add co-authors to this. Very well. We'll open the first roll for co-authors on this resolution, members. First roll for co-authors. Clerk will open for co-authors. This is for co-authors, members. This is for co-authors, members. Co-authors on the resolution. Clerk will close the roll. We have 49 co-authors. We can adopt the resolution by a voice vote. All those in favor signify by aye. Any opposed? The ayes have it. The resolution is adopted. Members, we'll go to file item 4. Mr. Krikorian is prepared to take up file item 4. Clerk will read.
Assembly Bill 671 by Assemblymember Krikorian and others, an act relating to the Golden Shield Award.
You may open, Mr. Krikorian.
Thank you, Madam Speaker. Members, AB 671 would create the California Golden Shield. Far too often each year in each one of our districts, we hear another tragic story about a public safety official who gives the ultimate sacrifice in the line of duty to keep the rest of us safe. Recently, the tragic loss of Los Angeles County firefighters Captain Ted Hall and firefighter specialist Arnie Quinones reminded us once again of the tremendous sacrifice that these brave firefighters and police officers and other public safety officials make to keep the rest of us safe. The California Golden Shield Act is a small measure that will give an official state recognition to those who give the ultimate sacrifice in the line of duty. And for the first time, California will have an honorific that's presented to any public safety official who's killed in the line of duty. This bill, of course, has strong bipartisan support, as it should. The Senate amendments simply made grammatical corrections and added co-authors. I respectfully ask for your concurrence in those amendments.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 55, noes 0. Senate amendments are concurred in. Mr. Torrico, for what purpose?
Thank you, Madam Speaker. If we could return to motion for resolutions,
Without
please.
objection.
The following are bills that there is unanimous consent to waive the one-day file notice requirements and to allow the bills to be heard today on third reading. They are as follows. File item number 15, AB 132. File item number 17, AB 146. File item 18, AB 147. File item 20, AB 236. File item 22, AB 244. File item 26, AB 287. File item 30, AB 402. File item 32, AB 473. File item 33, AB 513. File item 34, AB 527. File item 35, AB 685. File item 36, AB 730. File item 37, AB 798. File item 39, AB 828. File item 40, AB 852. File item 43, AB 943. File item 44, AB 1007. File item 45, AB 1079. File item 48, AB 1186. File item 50, AB 1366. File item 65, AB 395. File item 66, AB 666. File item 67, AB 750. File item 70, AB 1003. File item 71, AB 1070. File item 75, AB 1269. And finally, file item 84, AB 764. All of those are now eligible to be taken up.
Very well. Members, we now have quite a few bills that are eligible to take up. If one of those that were just read is your bill, please be prepared to present. Mr. Hagman is asking for a roll call vote before we accept these. We're waiving the one-day file notice. Members, Mr. Torrico is asking for an aye vote on the motion to allow us to take these bills up. Mr. Hagman is asking for a no vote. Clerk will open the roll. All members vote who desire to vote. Mr. Torrico is asking for an aye vote. Mr. Hagman for a no vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Torrico is asking for an aye vote. Mr. Hagman for a no vote. All members vote who desire to 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 vote. Mr. Torrico is asking for an aye vote. Mr. Hagman for a no vote. Clerk will close the roll, tally the votes. Ayes 41, noes 21. The motion carries. The bills are now eligible to take up today. So members, beginning with the bills that just became eligible, again, if that includes one of your bills, please be prepared to take that up. We'll go in file order as much as possible, beginning with file item 15 by Mr. Mendoza. Clerk will read.
Assembly Bill 132 by Assemblymember Mendoza and others, an act relating to pupil safety.
You may open, Mr. Mendoza.
Thank you, Madam Speaker. Members, I'm here to present AB 132 that states that immigration raids should not disrupt education in schools while maintaining conformity with federal law. This bill encourages schools to collect contact information from parents in case they do not get picked up after school to ensure that schools will have someone to release the children at the end of the day. Finally, unless required by federal law, the measure prohibits districts from asking students citizenship status, and schools are prohibited from discriminating on that basis. With that, I urge an aye vote.
Members, if we could have your attention. There's no debate or discussion. Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Mendoza moves a call. We'll move on to file item 17 by Mr. Mendoza. Clerk will read.
Assembly Bill 146 by Assemblymember Mendoza, an act relating to instructional materials.
You may open, Mr. Mendoza.
Thank you, Madam Speaker. Members, I'm here to present AB 146, which requires the delivery of instructional materials within 60 days of the date of purchase for school districts with 25,000 students or less. Amendments in the Senate basically limits that to small districts. With that, members, I respectfully ask for your aye vote.
Seeing no discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Mendoza moves a call. We'll move to file item 43 by Mr. Mendoza. Clerk will read.
Assembly Bill 943 by Assemblymember Mendoza and others, an act relating to employment.
You may open, Mr. Mendoza.
Thank you, Madam Speaker. Members, I'm here to present the last bill for today for me, AB 943, which would ban the use of pre-employment consumer credit reports. The credit reporting industry argues that the credit reports help employers determine the most qualified applicants for the job. However, there are many ways to screen applicants, and research shows that credit history does not predict job performance. Employers do not need access to applicants' personal financial information in order to evaluate their work ethic and trustworthiness. Members, I respectfully ask for your aye vote.
Ms. Harkey.
Madam Speaker and members, this is another job killer bill If you'll note the opposition to this, I mean, employers have to do some due diligence, and credit reports cannot be obtained without the person for whom the report is requested signature and authorization. So as part of an employment practice, if this is authorized by the person seeking employment, I can see no problem with it. I think that in this competitive job market, and also with of all the liability that employers face and the difficulty they have oftentimes in terminating employment if there is an error, I think it's very important to perform the due diligence ahead of time. Thank you. I request a no vote.
Seeing no further discussion, Mr. Mendoza, you may close.
Just Madam Speaker, it is the same job market that this bill is so important, that so many people are unemployed and are looking for jobs, and they need one less reason not to be hired. Background checks are more appropriate than credit checks, and with that, member, I respectfully ask for an aye vote. Thank you.
Clerk will open the roll. All members vote who desire to vote. 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 Clerk will close the roll, tally the votes. Ayes 42, noes 25. Senate amendments are concurred in. Mr. Swanson is prepared to take up file item 20. Clerk will read.
Assembly Bill 236 by Assemblymember Swanson, an act relating to car washes.
You may open, Mr. Swanson.
Members, Madam Speaker, thank you. AB 236 would extend the important car wash worker law. This would involve no new cost to the state. The Senate amendments extended the scheduled sunset date of the car wash worker law to January 2014. Specifically, the new motor vehicle dealers and automotive repair dealers who were not the intended targets of the original legislation are now exempt employers and therefore not subject to the provisions of this enforcement program. This is an attempt to develop a level playing field for law-abiding employers. AB 236 has no general fund costs, no opposition on file. I ask for your aye vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 42, noes 24. Senate amendments are concurred in. We'll move on to file item 22 by Mr. Bell. Clerk will read.
Assembly Bill 244 by Assemblymember Bell and others, an act relating to health care coverage.
You may open, Mr. Bell.
Madam Speaker and members, AB 244 is the Mental Health Parity Act for California. AB 244 requires health insurance corporations to cover treatment for mental health and substance abuse illnesses equivalent to coverage provided for other health conditions. So if you are sick and you are insured, your treatment is covered. This is a nonpartisan issue. President Bush signed the Wellstone-Domenici Mental Health Parity and Addiction Act in 2008. The federal act bans differences in mental health and addiction treatment for companies with 50 or more employees. On February 4th of this year, President Obama signed legislation reauthorizing the Children's Health Insurance Program Reauthorization Act, SCHIP, expanding coverages requiring mental health treatment. This is not a job killer list bill. And in fact, the California Health Benefits Review Project's estimated savings to the insured population of over $11 million annually. This is from a reduction of out-of-pocket expenses. The study indicated increase in premiums would be 4 to 38 cents per person per month for plans regulated by the Department of Managed Health Care. It's a cost-effective way to help people who are paying for health insurance to actually get the full scope health insurance they need. The Senate amendments on this bill were technical and clarifying only. Specifically, the amendments identified specialty health plans as those being exempt to the mental health and addiction services requirement. That's all the amendments do, and I asked for your aye vote respectfully on the amendments and this bill. Thank you.
Mr. Chesbrough.
Members, I rise in support of AB 244 and applaud my friend and colleague, Assemblymember Bell, for his dedication to this important issue. Parity is extremely important. I have, in the past, unsuccessfully authored bills on this same topic. In fact, I was a little bit ticked off at him for a while because I was never able to get the bill to the governor's desk. And in his first year as a freshman assemblyman, he did land this bill on the governor's desk only to have it vetoed. But I'm happy to be the co-author on this bill. This bill will bring better access to mental health services since it will finally put an end to the unequal and unfair discriminatory treatment of people who suffer from mental illness. AB 244 will also save the taxpayers of this state much needed money by treating people who suffer from mental illness before they become homeless, incarcerated, or hospitalized. Members, I urge your support for this very important measure.
Ms. Lowenthal.
Thank you, Madam Speaker. I, too, rise in support of this bill and thank Mr. Bell for his years of trying to create parity for serious mental illness. And members, the consequences of not allowing people to have the treatment that they need for serious mental illness is disastrous. It's costly for the state. It's costly for our families. As a mental health provider myself for many years, I saw that people struggled when they were not able to get the treatment. And again, the consequences are very, very painful for all of us as a society. Let's remove the stigma and let's support Mr. Bell's bill. Thank you.
Mr. Amiano.
Yes, thank you, Madam Speaker. And I do stand very strongly in support of Mr. Bell's bill. I want to applaud his action on this. This was not an easy road. Mental illness has been a stepchild for many, many years. And as my colleague, Assemblywoman Lowenthal, stated, the costs are immeasurable, not only financial costs, but emotional costs. This is really a bipartisan issue because mental health and mental illness stretches across all boundaries. It's about time that we paid serious attention to this. I urge an aye vote.
Ms. Harkey.
Madam Speaker and members, I am a strong supporter of mental health and support therefore. However, this bill adds such categories as mathematic disorder, spelling disorder, and other items that are not serious mental health disabilities. And I'm just having a problem with the volume of categories covered under this bill, and that the bill specifically exclude CalPERS and Medi-Cal health plans. So I would think that what was good for the goose would be good for the gander, and if we're going to do this, I would like to see it limited to those serious disorders that really need some help and not be an ever-expanding list of liabilities for insurers. So, and those of us who pay the premiums. So thank you. I respectfully will vote no, but I hope that we can find something a little bit more moderate come through that I could agree to. Thank you.
Mr. De Leon.
Thank you, Madam Speaker. I'm not going to get into the minutia of what's covered and what's not covered. I just want to thank the author very much for his strong leadership on this issue with regards to mental parity. I believe the Chabert analysis has come back would mean about 4 cents maximum with regards to premium payers on a monthly basis. It's something that's long been needed. I know I have family members myself who have been afflicted with mental health problems, and I just want to thank the author for his strong leadership on this issue.
Mr. Gaines.
Yes. Thank you, Madam Speaker and members. With all due respect to my fellow member, Mr. Bell, I think he's done great things in the health arena and mental health arena, but I've got some concerns about the broadness of this legislation and what the impact is on premiums, because currently we're covering 9 serious mental disorders, and those are very serious ones. We're talking about schizophrenia and bipolar and things of that nature, and those should be addressed, and perhaps it should be broadened. But when we broaden it to 250 listed items, I've got some real challenges as to whether those are completely legitimate or not, and then what is the financial impact to the buyer of health insurance in the state. So unfortunately, I'll have to vote no and urge a no vote. Thank you.
Mr. Manuel Perez.
Thank you, Madam Speaker. I, too, rise in support of this measure, and I appreciate the work of Mr. Bell. As a former director of community clinics, we often come across these type of issues, especially in low-income areas, underserved communities, and this measure would definitely support our work there. As knowing that the financial provisions are not available, and knowing that folks, particularly maybe farm workers, or what have you, they don't have any access to health care anywhere else. So I definitely appreciate this work. This is a very much needed measure. And thank you very much, and I ask for your aye vote.
All debate having ended, Mr. Bell, you may close.
Madam Speaker and members, I wanted to respond to several of the concerns by my colleagues, and I appreciate the fact that we all care about mental health and the concern for people with addiction. We all know that we need to treat it equally. I wanted to respond, first of all, to the concern that CalPERS and Medi-Cal is covered. Medi-Cal is not covered under this bill, and neither is CalPERS. Neither one of those two plans will be covered under this bill because the federal government legislation for Medi-Cal requires California to have a waiver agreement, which is a separate agreement that will cover any kind of medical, mental health, or addiction programs in the Medi-Cal system. That's a separate federal agreement with the state of California. The CalPERS plan is actually covered, and it's in the benefits review report. You can look up that in the report. It says that the federal law now covers the CalPERS plan. So this bill does not really have any implication or coverage issues with the CalPERS system, but the federal law does, and the federal law will require CalPERS to have mental health parity. The last issue, perhaps, is the list of issues covered, and the list of issues covered in this bill is strictly taken from the Psychological Standard Diagnostic Manual. There's a list of various ailments in that manual. The list includes several of the conditions mentioned by my colleague. However, the law that we're proposing allows insurance companies to use the utilization management programs, other kinds of techniques in terms of medical necessity, to limit the use of unnecessary medical care if the condition does not warrant it. So this does not change the system we have now in any other medical condition to say, hey, that really does not require medical treatment and is not medically necessary. So that issue is addressed in the bill. It does not change the ability of insurance companies to use utilization management techniques to control their cost. In fact, the cost is now pennies on the year, but however, the cost to the state government is billions of dollars for mental health and substance abuse conditions. This bill would save the state billions of dollars if fully implemented. It would have coverage for everybody. I urge an aye vote. This is a long time issue coming. The federal government has adopted it, and I urge an aye vote on this measure. Thank you.
Thank you, Mr. Bell. All discussion having ended, clerk will open the roll. All members vote who desire to vote. 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 Mr. Bell moves a call. Mr. Bell, are you prepared on file item 26? Clerk will read.
Assembly Bill 287
Mr. Bell, just one moment. Mr. Torrico.
Thank you, Madam Speaker. Form of announcement. The Natural Resources Committee will be meeting in 5 minutes at 3:45. Natural Resources at 3:45 in the Rules Committee room, and the Rules Committee itself will meet in the Rules Committee room at 5. Thank you.
So resources at 3:45 and rules at 5 o'clock. Continuing now with file item 26, clerk will read.
Assembly Bill 287 by Assemblymember Bell and others, an act relating to developmental services.
You may open, Mr. Bell.
Thank you, Madam Speaker and members. AB 287 directs the federally funded State Council on Developmental Disabilities, and I repeat, federally funded, to establish an employment-first committee which will develop and recommend to the legislature policies and strategies for increasing employment opportunities for people with developmental disabilities. The Senate amendments eliminate any general fund impact or cost pressures. The bill is strongly supported by the developmental disabilities community and has no opposition. I ask for concurrence in the Senate amendments.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Bell moves a call. We'll move to file item 26. Mr. Davis, clerk will read. File item 30 by Mr. Davis. Clerk will read.
Assembly Bill 402 by Assemblymember Davis, an act relating to employment.
You may open, Mr. Davis.
Thank you, Madam Speaker and members. AB 402, I'm asking for concurrence in the Senate amendments. As you know, 402 would require an attachment of proof of a Coogan account to a child's work permit that is submitted to the state. There is no opposition to this bill, and the Senate amendments asks basically for three things. One, an unannounced site visit to a randomly selected production facility. Two, it asks for funds from the work permit fund to be used for developing information and training for staff. And five, it asks that there be a sunset on the $50 required fee for the work permit by the date of January 1st, 2012. Finally, the support comes from the Screen Actors Guild, Biz Parents, and AFSCME. There, again, is no opposition, and I respectfully ask for your concurrence on these amendments.
Mr. DeVore.
Thank you, Madam Speaker and members. This measure, unfortunately, has a non-concurrence recommendation from the Republican caucus. And I would like to point out that this measure along with a measure in the similar field of entertainment that was passed yesterday, will, I believe, impact minor players, the people who aren't the major houses that run actors and actresses or child actors in Hollywood. What this bill does, in concert with the one that we passed yesterday that severely limits the ability of people who are talent agencies to operate, what this bill does is increase the barriers for people to participate as extras in Hollywood. And, of course, one of the reasons why I know this is that my two daughters have been participating as extras on a popular TV studio set. And what's going to happen then with this fee is that on a regular basis, children are going to have to pay for the right to work. Now, the challenge here is, just as with a third bill that we considered on this floor, just because you're paying, in this case you're paying the state, doesn't mean that you have a guarantee of work. And so what you're going to find is that many children who desire the opportunity to take and have the chance to be an extra are going to be laying out $50, presumably every 6 months, for the possibility of potentially working. And for many families that are in more difficult economic situations, what this will mean is that, practically speaking, they won't even try, because they can't take the gamble on laying out $50 constantly and then not actually get called and go in and work. So, ladies and gentlemen, I would submit to you that in this time of economic distress with high unemployment, the last thing we want to do is erect a barrier where non-professionals have to pay the state constantly for the right to even be considered to have a job. I would submit that if it is the state's responsibility, if somehow the state feels that they need to be engaging in some regulatory oversight of this industry, as has been the case, that this is something that, if it's worthwhile, is funded out of the general fund, rather than out of fees that come out of the pockets of the children or of their families who are struggling to make ends meet. For this reason, ladies and gentlemen, for the fee specifically, I would strongly urge a no vote on this measure.
Seeing no further debate or discussion, Mr. Davis, you may close.
Thank you, Madam Speaker and members. Clearly, we have missed the point on the purpose of this bill. The Coogan Act requires that children are not the victims, unfortunately, of parents who take their money after they've made a substantial amount, oftentimes, after working as a child actor. And this bill will ensure not only that we require a Coogan Act account to be available, that in fact we have one in evidence. So therefore, this bill requires that there is a receipt attached thereto the employment work permit of our children. And as we know, this economic downturn time requires that departments become more self-sufficient when necessary. The fee that we are imposing will create the appropriate funds for us to additionally make sure that we can monitor the work sites, as has been indicated in the Senate amendments. And so therefore, we will, in fact, go without prior warning to certain facilities, entertainment facilities, to do an appropriate risk assessment to make sure that this law is in fact in place. With that, ladies and gentlemen, this bill simply will make sure that our children who happen to be in the entertainment industry and who gain a work permit from us have a system on behalf of the state that is working effectively to ensure that they are protected, and unfortunately, sometimes from their parents, who take their money, as has been done time in and time again, and spend that money, and when they become of age, they have no money set aside from the work that they have done. Therefore, ladies and gentlemen, I ask again for your concurrence on these Senate amendments.
Debate is ended. Clerk will open the roll. All members vote who desire to vote. 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 Clerk will close the roll. Tally the votes. Ayes 41, noes 23. Senate amendments are concurred in. We'll go to file item 35, also by Mr. Davis. Clerk will read.
Assembly Bill 685 by Assemblymember Davis, an act relating to school facilities.
You may open, Mr. Davis.
Thank you, Madam Speaker and members. I am presenting AB 685 and asking for also concurrent Senate amendments. The bill itself will require school facilities planning divisions of the State Department of Education to include as a part of its existing review process of applications for new construction plan approval whether the proposed project would comply with Title IX. The Senate amendments specifically require that there be a review only on new athletic facilities, and that the Department of Education convenes a working group to develop guidelines for compliance within the existing budget. These measures clearly will save us money in the long run. Therefore, it is important for you to know that AB 685 has wide support and has no opposition. I respectfully ask for your concurrence on Senate amendments.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. 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 Clerk will close the roll, tally the votes. Ayes 41, noes 20. Senate amendments are concurred in. We'll move to file item 33. Mr. De Leon, clerk will read.
Assembly Bill 513 by Assemblymember De Leon and others, an act relating to health care coverage.
You may open, Mr. De Leon.
Thank you, Madam Speaker. Members, AB 513 will ensure that HMOs and insurers cover the cost of quality pumps to help mothers continue to breastfeed after returning to work. This measure will ensure that HMOs as well as insurers provide coverage for new mothers to see a board-certified lactation consultant to help facilitate the breastfeeding process. Amendments have been taken in the Senate and are technical in nature and clarify the intent of this measure. This legislation is a crucial step to help all mothers who wish to breastfeed their children. Members, must I remind you that the vast majority of women of color in the state of California do not breastfeed because of severe health issues. They need assistance, and that's why a lactation consultant, a professional, is necessary for a first-time consultant. Members, I respectfully ask for an aye vote.
Ms. Harkey.
Madam Speaker and members, I think this is a little bit of an overreach. Having been a woman working and having breastfed my child, I found a way to make it happen. I understood it immediately, and even if I didn't understand it, believe me, my baby did. So I think that there's a little bit too much made of this, and I would hate to see another mandate placed on employers, insurance companies, and everyone else for something that a woman may choose to do or not, and that a child may take to or not. And so I appreciate the sensitivities here, but I really think this is another unnecessary bone to throw at women in the workforce that may in fact end up ricocheting back at us. Thank you.
Before you close, Mr. De Leon, members, Natural Resources is meeting immediately. Natural Resources Committee is meeting in the Rules Committee room. All discussion and debate having ended, Mr. De Leon, you may close.
Thank you very much, Madam Speaker. I just want to emphasize, and I respect Ms. Harkey's comments as well as her opinion with regards to this issue, but this is a public health issue. It's a public health issue because the evidence clearly suggests, it shows us that babies that are breastfed have less ear infections, their immune systems are much stronger. Simply put, they grow up to be young, healthy children that are productive. They're not as sick. Adults, parents, particularly mothers, don't lose days of work, having to take care of their children, taking their children to the hospital, to the clinic, or to the doctors. This is a good public safety issue, health issue for these children. Moreover, I think it's inherently unfair that women have to pay thousands and thousands of dollars out of their own pocket out of their own pocket to consult with and to rent and hire a lactation consultant. This is a common sense bill. You know, I hear it, I understand the overtones, if you will, with regards to this measure, but this is a good public health bill for mothers in the state of California. I respectfully ask for your aye vote.
All debate having ended, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes, ayes 43, noes 24. Senate amendments are concurred in. We'll return to file item 32 by Mr. Blumenfield. Clerk will read.
Assembly Bill 473 by Assembly Member Blumenfield, an act relating to recycling.
You may open, Mr. Blumenfield.
Thank you, Madam Chair. This bill is about apartment recycling. It's about giving renters the ability to recycle in the places where they live. And I want to speak specifically to my Republican colleagues for a moment, because when this bill passed out of the Assembly, it was pretty much a party line vote. However, I have worked very closely with all the opposition, with the building owners, apartment owners, and all of the opposition has been neutralized. No one is opposing this bill anymore. No groups are opposing this bill. We've found a way to deal with all of the issues concerning space, concerning financial hardship. This is a good bill. It's also it's important to know that this can save apartment owners money. The City of San Diego published a sample cost on their website that demonstrates that recycling can, in fact, reduce the cost of waste services for an apartment owner. Diverting recyclable trash away from landfills reduces the need for waste. If you're one of the 7 million people living in an apartment, you deserve the chance to recycle. Again, I ask people to look at this bill with fresh eyes. It's not the bill that's been in years past, and it's not even the bill that we passed here in the Assembly. It has no opposition. I ask for your aye vote.
Ms. Harkey.
Question of the author.
Without objection.
Was the Apartment Association opposed to this initially?
Yes, they were.
And they've dropped their opposition?
They have dropped their opposition. We have a letter to that effect, and we work closely with them.
Thank you. Okay, on my own time, please. I strongly support this, and let me tell you why. I didn't when it created a lot of problems for all of the apartment owners, and apparently the amendments that have been taken have eliminated those. I have dealt with this on multiple units personally, and I'm always amazed when I go into large cities, and like right now in Sacramento, that we have no recycling availability. If recycling is important for all of us in the suburbs, I would think it would be doubly important here if it is to accomplish its goals, to be in the city where there are great concentrations of people. And if in fact it does help relieve some of the landfills, I think we ought to be looking at it, and I would consider supporting this since the author has worked with the opposition and apparently reached some common sense agreements. So I do ask for your aye vote, and even if I stand alone, I think I'm going to go up on this one. Thank you.
Seeing no further discussion or debate, Mr. Blumenfield, you may close.
I respectfully ask for your aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll. Tally. All members vote who desire to vote. Clerk will close the roll. Tally the votes. Ayes 41, noes 14. Senate amendments are concurred in. We move to file take up file item 36, Mr. De La Torre. Clerk will read.
Assembly Bill 730 by Assembly Member De La Torre, an act relating to health insurance.
You may open, Mr. De La Torre.
Thank you, Madam Speaker and members. AB 730 requires a health insurer that unlawfully engages in post-claims underwriting be liable to the state for a civil penalty to be fixed by the California Insurance Commissioner in an amount not to exceed $5,000. AB 730 was amended in the Senate to deposit the fines into the major risk medical insurance program, leaving the original amount that went from the fee in the general fund. I respectfully ask for your support on the concurrence.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. 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 Clerk will close the roll, tally the votes. Ayes 41, noes 19. Senate amendments are concurred in. We're going to move to file item 67. Mr. Nava, thank you for your patience. Your seatmate has moved ahead. File item 67, clerk will read.
Assembly Bill 750 by Assemblymember Bass, an act relating to drug diversion.
You may open, Mr. Amiano.
As you know, ensuring successful reentry for offenders is emerging as a major priority in California. AB 750 establishes a model program for reducing recidivism among nonviolent offenders. The model is based on a program called Back on Track, a San Francisco program that the National District Attorneys Association recently named a national model. Senate amendments were technical in nature. I ask for your aye vote.
Mr. Hagman.
Thank you, Madam Speaker. I do regret to rise to oppose this at this point. I've tried to work with Madam Speaker on this bill in committee, and this will just send the right direction. We're letting low-level drug offenders and medium-level drug offenders out early without the preparation to keep them from going back to their drugs. They can also bargain down, when you get arrested, you bargain down these charges down to a lower lesson possession for sale versus dealing charges, and so you already start off with a lower playing field. Deep concerned that AB 750 be used simply as an excuse to give higher-level drug dealers the opportunity to get back in the streets quickly. We should all be concerned that this bill does not limit itself to eligibility for probation only. Indeed, this bill allows major drug sellers to participate even if they're not eligible for probation. This will give some very dangerous people back the opportunity to reduce their sentences to get back to the drug trade upon their release. Although the state should make meaningful rehabilitation a reality for people convicted of a drug offense, this rehabilitation should not be in conjunction with their prison sentence. In other words, we should not use rehabilitation as an excuse to water down our tough-on-crime laws that put public safety at risk. I urge you no vote.
Seeing no further debate or discussion, Mr. Amiano, you may close.
Yes, this is a wonderfully innovative and effective program. It doesn't water down anything. As a matter of fact, it's proven itself effective and is a great template for other cities to follow. I urge an aye vote.
It's getting a bit noisy, members. I want to make sure you know we are about to vote. Clerk, please open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 42, noes 19. Senate amendments are concurred in. Now we will return to file item 37. Mr. Nava. We'll return to file item 37 by Mr. Nava. Clerk will read.
Assembly Bill 798 by Assemblymember Nava, an act relating to transportation and make an appropriation therefore.
Now it's your turn, Mr. Nava. You may open.
I'm so excited, Madam Speaker. This is Assembly Bill 798. The Transportation Financing Authority. Capacity demands on transportation infrastructure in our state, combined with declining revenue streams for project financing, have severely eroded our transportation systems. Vote yes. As federal and state funding have declined, local governments have stepped up their funding for transportation projects and now account for the largest share of state transportation financing. Local governments are willing to contribute even more. AB 798 sets up the California Transportation Financing Authority to help address this problem and allow local governments another financing option for transportation projects. Under the bill, CTFA is authorized to issue or approve the issuance of revenue bonds for the construction or repair of publicly owned transportation projects. Amendments in the Senate were relatively minor and expanded the definition of what projects would be eligible for financing. Ask for an aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. 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 Mr. Nava moves a call. We move to Mr. Liu, file item 39. Clerk will read.
Assembly Bill 828 by Assemblymember Liu and others, an act relating to building standards.
You may open, Mr. Liu.
Thank you, Madam Speaker and members. This bill establishes a comprehensive process for developing statewide green building standards that incorporate expertise from state agencies responsible for protecting California's public health and environment. The Senate amendments added the Housing and Community Development Department to a list of state agencies whose input to the Building Standards Commission they must seek and respond to when developing such standards. They also deleted the requirement that a green building standard adopted or approved by the Commission be inserted into the relevant part of the Building Standards Code. This bill is sponsored by the NRDC Environmental Defense. We worked with all the stakeholders, and there is now no longer any registered opposition. We respectfully request an aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Liu moves a call. We'll go now to Mr. Fong, file item 40. Clerk will read.
Assembly Bill 852 by Assemblymember Fong, an act relating to taxation.
You may open, Mr. Fong.
Thank you, Madam Speaker and members. AB 852 authorizes a county assessor to require a business to electronically file a business property statement if they own taxable personal property with an assessed value of $100,000 or more. Amendments taken in the Senate add protections for small businesses and make other clarifying changes. AB 852 is sponsored by the California Assessors Association and is supported by the California Taxpayers Association. I respectfully request your concurrence in Senate amendments.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Fong moves a call. We'll go to Ms. Carter with file item 44. Clerk will read.
Assembly Bill 1007 by Assemblymember Carter and others, an act relating to governing boards.
You may open, Ms. Carter.
Thank you, Madam Speaker and members. The amendments in the Senate for AB 1007 were technical in nature and added a co-author. This measure has received strong bipartisan support as it has gone through the legislative process. I ask for your aye vote on concurrence in Senate amendments.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 42, noes 10. Senate amendments are concurred in. That takes us to Mr. Blumenfield, file item 48. Clerk will read.
Assembly Bill 1186 by Assemblymember Blumenfield, an act relating to air pollution.
You may open, Mr. Blumenfield.
Thank you, Madam Chair. Members, this bill, the parking cash-out disclosure bill, was amended in the Senate. I want everyone to take a second look at this bill as well, because we've removed all opposition from this bill. There was some of the building owners and apartment owners were concerned about it. All opposition has been removed. Although it deals with the underlying issue of the parking cash-out program, the bill really is not about that. It's about disclosure of leases, and it basically just says if you have 50 or more employees, and you have a specific amount that you're subsidizing that parking, that you disclose that either in the lease or through a written letter. And this will work whether you favor parking cash out on the state level or whether you favor it on the local level. This bill is good to promote that, and I ask for your aye vote.
Seeing no discussion or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Mr. Blumenfield moves a call. We'll go to file item 50. Mr. Fuhrer, clerk will read.
Assembly Bill 1366 by Assemblymember Fuhrer, an act relating to water softeners.
You may open, Mr. Fuhrer.
Thank you very much, Madam Speaker. This is a bipartisan bill that got 60 votes on this floor previously. I'm very proud to be a joint author on this bill with our colleagues Ms. Caballero and Ms. Strickland. The purpose of this bill is to empower local governments to control salinity in their water supplies. By doing so, they can facilitate water recycling, avoid major penalties that their ratepayers need to pay, and so on. Amendments taken in the Senate, as this bill is now on concurrence, amendments in the Senate were largely technical in nature, but important enough that they removed opposition to the bill from the major associations which had previously opposed the bill. And indeed, one prior opponent of the bill has now become a supporter of the bill. So there's very limited opposition at this point because of the consensus that evolved in the Senate amendments. And with that, bipartisan support, urge an aye vote.
Ms. Strickland.
Thank you, Madam Speaker. Members, AB 1366 will give local communities that are in the most sensitive areas of our state all of the tools necessary to protect the water supply. With the increased salinity levels beginning to impair both, obviously, the groundwater and the surface water, our agricultural livelihood is being threatened, and that's why I'm a joint author on this bill with Mr. Fuhrer. And that's why the farmers of this state actually support this bill as well, too. And it's important that we do all that we can to prevent salts from all types of sources from entering our water supply. Anyone who owns a water softener device has an obligation to make sure that any discharge from their appliance is contained fully within their own property, and there should be no right for anyone to leach contaminants into their neighbor's property. AB 1366 protects you and your water system from your neighbors and the contaminants that your neighbor is generating by using a water softener and then depositing them into a common water supply. This bill is a public safety bill as much as it is an environmental protection bill, and I would urge your aye vote.
Mr. Gaines.
Yes, thank you, Madam Speaker. Members, could I ask a question?
Without objection.
I was just curious in terms of the takings aspect of this legislation, and I'm curious as to whether it's being addressed or not, that you have a lot of businesses that provide water softeners to folks throughout the state, and how does this legislation treat it?
Yeah, well, let me say, first of all, that there is no takings issue associated with this legislation. If there is a buyback program that a local jurisdiction decides to put in place, then it's a buyback program of compensation. And I want to point out that I mentioned associations that had formerly been opposed to the bill had removed their opposition. These are associations comprised of those who provide water softeners. The Pacific Water Quality Association and the Water Quality Association. And by the way, salt companies. Cargill Salt formerly opposed the bill. Now it's off the bill. Even the machinists of California who formerly were opposed to the bill now support the bill. So from every standpoint, including those important to the providers of softeners themselves, their associations at least, this is a supportable bill.
I'm seeing a lot of vendors here who are in opposition of the legislation, and I'm just wondering if...
What?
Well, I've got a whole list here of folks who are in opposition. Okay, we've got AAA Water Systems, Alaska Water Air Conditioning, Aloha, Alkion. I mean, I could go right down through the list.
Yeah. Mr. Gaines, for what it's worth, the opponents who have officially registered support on this bill have dwindled now to 3. Culligan, Home Depot, and the California Retailer. The supporters of the bill, by contrast, are so many that it would take me about 10 minutes to read them all, and I can do that in my close if you'd like.
Okay,
but the associations that to which those organizations belong have removed their opposition to the bill.
One final question, and I'll sit down, if I could, please.
One final question.
Is there compensation by a local government or any governmental entity for a taking as a result of losing business because of this legislation for a water softening company?
Again, the associations of water softeners have removed their opposition to the bill. Local governments would require, if a water softener was to be removed in, say, a voluntary buyback program, they require compensation to the entity, to the individual whose softener is removed. There is no specific provision providing any monetary benefit to any water softener company.
Seeing no further discussion or debate, Mr. Fuhr, you may close.
Thank you very much, Madam Speaker. So this is a bill that enjoys incredibly broad support. The agricultural community supports this bill. Chamber supports this bill. Environmental community leaders support the bill. Numerous water and sewer districts, cities, and other interests support the bill. As I mentioned a few times, former opponents of the bill have removed their opposition, including the associations to which companies that sell water softeners belong, because we've taken amendments that have found common ground with them. Again, a bipartisan bill that had 60 votes on this floor before those amendments removed that opposition. I urge and I vote now that we've reached so much consensus.
All debate having ended, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 43, noes 9. Senate amendments are concurred in. We go now to file item 66 by Mr. Jones. Clerk will read.
Assembly Bill 666 by Assemblymember Jones and others, an act relating to subdivisions.
You may open, Mr. Jones.
Thank you, Madam Speaker. Members, this Bill 666 coincidentally does deal with fire protection. We took a hit for the team when we were in line to get bill numbers. I'm sure you all thank me. The bill's back for concurrence in Senate amendments. The bill enjoyed bipartisan support when it left this floor. The technical amendments in the Senate were done at the request of the administration. The bill simply makes sure that in high-risk fire areas we're considering whether there's adequate local fire protection before proceeding. I ask for your aye vote.
Mr. Amiano.
Yes, question for the author.
Without objection.
Mr. Jones, is the devil in the details?
Mr. Amiano, I thought where you were going to go was the devil and Miss Jones, but the answer is no.
Seeing no further discussion, Mr. Jones, you may close.
I ask for your aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 47, noes 14. Senate amendments are concurred in. We go to file item 70. Mr. John Perez. Clerk will read.
Assembly Bill 1003 by Assemblymember Perez, an act relating to domestic violence.
You may open, Mr. Perez.
Thank you, Madam Speaker. Members, AB 1003 makes various changes to the law regarding the Prevention Services for Domestic Abuse Fund. The purpose of this program is to provide grants to organizations that are able to provide the best culturally appropriate education and services for lesbian, gay, bisexual, and transgender victims of domestic violence. Senate amendments require CalEMA to consult with the Department of Public Health to consider the consolidation of their respective domestic violence programs and report conclusions to the legislature by June 30th, 2011. They clarify that grant recipients shall provide a 10% match of the funds received. The Secretary of CalEMA may waive the matching fund requirement at his or her discretion. This amendment was requested by CalEMA. Additional amendments are technical and clarifying, including the reordering of services an organization should also provide to be funded as part of the grant program. These changes ensure review by all recipients based on current proposals and would allow for better competition for limited funds. This requires no new fee. In essence, all this does is create greater competition for the provision of services to this specific group of domestic violence victims, and I respectfully ask for your aye vote.
Mr. Hagman.
Thank you, Madam Speaker. At this time, I must regretfully ask for the Republicans to lay off this or vote no, and further deliberate this at a later time.
Seeing no further debate or discussion, Mr. Perez, you may close.
Madam Speaker, I ask all members to join me in supporting this bill. The reality is, if it wasn't for the group of victims that we were discussing, we would not have any issue about getting concurrence from the vast majority of members of this House. When I took this before committee, I was asked to address the issue of matching funds. We've taken that. The only issue at play here is who the victims of the domestic violence are. And I think that we as a body should say that all victims of domestic violence should have access to the services that they deserve based on the crime that they were victims of. The funding for this has long been established in the fees that individuals pay when they file as domestic partners, similar to the way in which marriage fees are used for opposite gender domestic violence funds. There is no legitimate reason to oppose this bill other than people's fear of standing up for same-gender victims of domestic violence. I ask for your aye vote.
All debate having ended, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 44, noes 21. Senate amendments are concurred in. Mr. Torrico. For what purpose?
Thank you, Madam Speaker. If we can return to motions and resolutions, please.
Without objection.
Hereby request unanimous consent to waive the following requirements to allow the Business and Professions Committee to hear AB 1071 by Dr. Emerson and SB 819 by the Committee on Business, Press, and Economic Development immediately.
Without objection.
Madam Speaker, I request unanimous consent to waive the following requirements to allow the Committee on Governmental Organization to hear AB 246, AB 1577, and SB 131 today upon call of the Chair.
Without objection.
Madam Speaker, I request unanimous consent to rescind the action whereby file item 18, AB 147, by Ms. Saldana was referred to the Environmental Safety and Toxic Materials Committee today and return the bill to the unfinished business file for concurrence.
Without objection.
Madam Speaker, at the request of the author, please send file item number 140, SB 401, to the inactive file.
I'm sorry, Mr. Torrico, can you repeat that, please?
Sure. At the request of the author, please send file item 140, SB 401 by Senator Wolk, to the inactive file.
Clerk will note.
And finally, Madam Speaker, I request unanimous consent to suspend the rules to allow Assembly member to take up his ACR 94 without reference to file for the purpose of third reading today.
Mr. Hagman's okay with that, without objection.
Okay, so did you announce the hearing?
Members, Business and Professions Committee will meet immediately in the Rules Committee room. Business and Professions in the Rules Committee room. We'll also go to Mr. Fuentes' file, item 65. Clerk will read.
Assembly Bill 395 by Assemblymember Fuentes, an act relating to employment.
You may open, Mr. Fuentes.
Thank you, Madam Speaker. This bill will allow the Department of Industrial Relations to authorize specific labor compliance programs to enforce prevailing wage laws and other requirements that apply to apprenticeships on public works projects. Amendments taken in the Senate address concerns raised by the Department of Industrial Relations, and the Department is now neutral on the bill. This bill is co-sponsored by the City of Los Angeles and the State Building and Construction Trades Council, as well as the California Labor Federation and AFSCME. I ask for an aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. 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 Mr. Fuentes moves a call. We'll move to file item 75 by Ms. Brownlee. Clerk will read.
Assembly Bill 1269 by Assemblymember Brownlee, an act relating to Medi-Cal.
You may open, Ms. Brownlee.
Thank you, Madam Speaker and members. AB 1269 is back for concurrence. This bill was amended in the Senate to delay implementation until the Federal American Recovery and Reinvestment Act of 2009 sunsets, which will likely be January 1st, 2011. This technical amendment was taken upon request of the Department of Health Care Services so as to not jeopardize any provision of the Act. AB 1269 will encourage participation in the Medi-Cal Working Disabled Program and is strongly supported by the disability community, employers, and state agencies. I respectfully ask for your aye vote.
Seeing no debate or discussion, clerk will open the roll. All members vote who desire to vote. 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 Ms. Brownlee moves a call.
We'll move to
file item 71AB 1070. Mr. Hill, clerk will read.
Assembly Bill 1070 by Assemblymember Hill, an act relating to healing arts.
Mr. Hill.
1070 seeks to ensure that the Medical Board of California continues protecting health care consumers in our state by enacting technical changes to existing programs that will help the board enforce proper reporting, licensing, and regulation of physicians and surgeons. Senate amendments extend the sunset for the vertical enforcement program between the board and Department of Justice and would also require notification to a physician if he or she is named in an action. Members, this is a good consumer protection bill. I respectfully request your aye vote on concurrence.
Seeing and hearing no debate discussion, clerk will open the roll. All those vote who desire to vote. 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 Mr. Hill moves the call. Move to file item 18, AB 147. Ms. Saldana, clerk will read.
Assembly Bill 147 by Assemblymember Saldana and others, an act relating to hazardous waste.
Ms. Saldana.
Thank you, Mr. Speaker. Members, AB 147 will allow but not require the Department of Toxic Substance Control to request documentation from electronics manufacturers regarding the amount of hazardous materials in their consumer products. Amendments were taken in the Senate to address issues raised by the industry. We have removed the opposition as a result of the amendments. We've narrowed this version of the bill, and it currently has no opposition. I ask for your aye vote on Senate amendments.
Seeing and hearing no debate or discussion, clerk will open the roll. All those vote who desire to vote. 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 Ms. Saldana moves the call. Move to file item 131, SB 792 by Mr. Leno. Ms. Ma will be presenting. Clerk will read.
Senate Bill 792 by Senator Leno, an act relating to tidelands and submerged lands.
Ms. Ma.
Thank you, Mr. Speaker. Members, this is a critically important bill for the city and county of San Francisco, and in particular for the Bayview community, a largely underserved neighborhood in the southeast section of the city that lacks many of the public benefits that this bill will help deliver. SB 792 would grant the California Department of Parks and Recreation the authority to exchange park lands once it has determined that the park within the project meets the existing and the bill's higher environmental standards. The bill's provisions were the product of lengthy negotiations initiated by the author with organizations representing diverse local and state interests. The current version of the bill includes amendments that specifically remove the opposition of the State Sierra Club, the Friends of Candlestick, and ARC Ecology. This bill does not require the exchange of any lands, nor does it exempt the project from any existing environmental reviews. An EIR and a CEQA review must still be completed before the project moves forward. SB 792 simply grants the state the authority it needs to modify state park land boundaries and receive funds to support and improve the park in the future. Amongst the many public benefits is many, and given the hour at this moment, I will skip over the benefits. However, this project is one of the largest and most significant park construction projects in San Francisco since Golden Gate Park, at no cost to the city's general fund or the state. The bill is supported by a broad and lengthy list of local groups and individuals, including Sophie Maxwell, who represents the project area on the San Francisco Board of Supervisors, the San Francisco Labor Council, San Francisco Acorn, the Bayview Merchants Association, the San Francisco Organizing Project, the San Francisco Chamber of Commerce, the African American Revitalization Consortium, and the Alice Griffith Tennis Association, and many more. Respectfully ask for your aye vote.
Mr. Almiano.
Thank you, Mr. Chair, I stand in opposition to this bill. I do represent this district, and it's a sad story. There's good people on both sides of this. It's a very contentious issue. I did not support a ballot measure. I supported an opposition measure, which in fairness, did lose. The Sierra Club's opposition to this surfaced after the ballot measure passed, and they realized that there was park lands involved. It's true that they are now neutral, but there are still park lands that are involved less, which is a good thing. But because there are still these parklands still in contention, I feel we're setting a very bad precedent here by moving forward on this, especially with the state closing parks. Again, there are good people on both sides, Friends and Labor, community groups. However, this is not something I need to be consistent about. I do not support this bill, and urge a no vote.
Ms. Small, you want to close?
No, respectfully ask for your item members.
Very well. Clerk, open the roll. All those voters desire to vote. 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 Clerk will close the roll. Tally the votes. Ayes 46, noes 1. Measure is adopted. Move to file item 84, AB 764, Mr. Nava. Clerk will read.
Assembly Bill 764 by Assemblyman Nava and others, an act relating to real estate brokers.
Mr. Nava.
Thank you, Mr. Speaker and members. This is AB 764, authored by Nava, Bass, and Fuhrer, the Homeowner Fraud Prevention Act. This is here for concurrence. The bill ensures that California homeowners are less vulnerable to loan modification scams. These predators charge our homeowners a fee when they which can reach several $1,000s with the promise of a loan modification. Most often, these predators provide loan modification services for an upfront fee or even a pay-as-you-go method with little or no results. This bill is a well-rounded approach that will protect our financially distressed homeowners at every angle by prohibiting the collection of a fee until the loan has been modified. This bill contains a number of other provisions, including requiring those wanting to charge a fee for loan modifications to notify the homeowners that there are free services. It also prohibits advertising that uses words, letters, initials, symbols, or other devices that are similar to those used by a governmental entity or a nonprofit agency. This bill is supported by the California Reinvestment Coalition, CalPERG, Consumers Union, AARP, California Labor Fed, Los Angeles Mayor Antonio Villaraigosa, and the State Bar of California. Ask for an aye vote.
Mr. Vines.
Thank you, Mr. Speaker. Question of the author.
Without objection.
Does this have anything to do with T. Ridge?
No, but I'm glad that you brought up the issue of T. Ridge, because T. Ridge actually does come closer to a misrepresentation on the public rather than homeowner fraud.
Mr. Nava, make sure your comments
It was absolutely germane, Mr. Speaker.
Well, please make sure that they are.
No, absolutely germane. But thank you for that opportunity.
Seeing and hearing no further. Oh, yes, Ms. Harkey.
Question of the author.
Without objection.
I'm not going to make fun of this. I have some serious questions because I think this may be a good bill. If there are fees related with, like, processing credit reports, out-of-pocket fees, are those able to be collected ahead of the closure of the loan?
Yeah, what we prohibit is the collection or the payment of advance fees in order to obtain a loan modification. If there are ancillary services associated with helping a homeowner, those are not prohibited. But what we're looking to prevent are those individuals and some businesses that approach a homeowner who is in foreclosure and say, for $3,500, for $7,000, I will negotiate with your lender in order to get you a modification, and then don't deliver the actual loan modification. This is analogous to a loan broker. Those of you that are in the real estate business, you know if you're a loan broker, you don't get paid until you complete the work. My bill says you don't get paid until you complete the work of a loan modification.
On my own time, please.
Without objection.
Members, I was greatly conflicted on this, but I am with it in spirit, and I'll tell you why. There were, and there still are, a lot of people scamming for this type of business. And quite honestly, brokers need to be registered and have passed an exam, and they cannot collect fees, only out-of-pocket fees or out-of-pocket expenses prior to closing a loan. So I really don't think an upfront I'll look for it fee should be collected until the loan is actually consummated. So I do support this. It is one of those issues where I know it's, and I noticed the California Association of Mortgage Brokers, I believe, yeah, they have dropped their opposition. So they were opposed, I think, initially, and apparently some of this has been worked out. I would encourage a support on this because I think it's just a good business practice, especially in this day when there's so many people that need help and may not know where to go. They at least need to know that they're going to get their help if they pay a fee. Thank you.
All debate having seats. Clerk, open the roll. Mr. Nava, you may close.
Thank you. In closing, the provisions of this bill are enforceable, unlike those of T. Ridge. Ask for an aye vote.
What a nice close, Mr. Nava. Very well done. Clerk will open the roll. All those vote desire to vote. 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 Clerk will close the roll. Tally the votes. Ayes 47, noes 15. Measure is adopted. Move to file item 164, SB 519 by Senator Ashburn. Dr. Hernandez will be taking this up. Clerk will read.
Senate Bill 519 by Senator Ashburn, an act relating to public employment.
Dr. Hernandez.
Thank you, Mr. Speaker and members. SB 519 will provide legislative approval for the collective bargaining agreement between the state and the Bargaining Unit 5, the California Association of Highway Patrol. The agreement requires that any salary increases for patrol officers that would have been required by law will instead go towards pre-funding retire health care costs for patrol members, their beneficiaries, and survivors. This is the first agreement between the state and the state bargaining unit that addresses the need to pre-fund the cost of retiree health care. It will save billions of dollars over time, and pre-funding for retire health care benefits was one of the primary recommendations of the governor's bipartisan Employee Post-Employment Benefit Commission. I respectfully ask for your aye vote.
Seeing and hearing no debate or discussion. Oh, I'm sorry, Mr. You're being blocked by Mr. Logue. Mr. Gilmore.
Easily done by Mr. Logue. We needed a little smile in the chamber today. There's been a lot of doom and gloom. Thank you, Mr. Speaker. Members, I'm proud to see that the California Highway Patrol has led the way on this very important issue that for the pre-funding for retirees on medical care, and I'm just really pleased to see that's done. Thank you.
Seeing and hearing no debate discussion, clerk will open the roll. All those vote desire to vote. All those vote who desire to vote. All those vote desire to vote. All those vote who desire to vote. Clerk will close the roll. Tally the votes. Ayes 54, noes 1. Measure is adopted. Move to file item 127, SB 820 by Senator McLeod. Mr. Ruskin will be presenting. Clerk will read.
Senate Bill 820 by Senators Negrete McLeod and others, an act relating to healing arts.
Mr. Ruskin. Mr. Ruskin, yes.
Speaker, SB 820 makes various changes relating to the peer review process for physicians and to the medical board reporting process for final disciplinary actions taken by a peer review body against a physician. This bill requires a physician peer review body of a hospital to make a confidential report to the medical board regarding a disciplinary action they've taken against the physician. This confidential report would only be sent to the board, however, if the physician caused patient harm or death, was involved in excessive prescribing or furnishing of drugs, or was found to be involved in sexual misconduct with a patient. This bill is intended to get at the more serious cases of physician incompetence, negligence, or wrongful behavior. The measure also clarifies current provisions regarding the reporting of physicians who are suffering from a disabling mental or physical condition and who pose a threat to the patient. This early reporting requirement will allow the medical board to move ahead with its own independent investigation of the physician and to make a determination of any action that needs to take place regarding their status to practice. However, this bill will not in any way interfere with the physician's ability to contest or appeal the action by the peer review body within the hospital. I ask for your aye vote.
Seeing no debate or discussion, clerk open the roll. All those voters desire to vote. 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 Clerk will close roll. Tally the votes. Ayes 54, no 0. Measure is adopted. Move to file item 165, SB 769 by Senator Alquist. Mr. Fong will be presenting. Clerk will read.
Senate Bill 769 by Senator Alquist, an act relating to federal funding.
Mr. Fong.
Thank you, Mr. Speaker and members. This is about SB 769, the swine flu funding. This is an urgency clause. Is needed for SB 769 as it relates to federal funds to be used to address the H1N1 pandemic, commonly known as swine flu. The urgency clause is needed so the distribution of funds, with 70% going to the local health jurisdictions, can take place prior to January 1, 2010. If the bill does not take effect until January 1, 2010, then the funds will not flow as specified until after this year's flu season. I respectfully request an aye vote to allow an addition of an urgency clause to this measure that will ensure local health jurisdictions will have enough help to see them through this flu season. I respectfully request an aye vote.
These are on amendments. We'll have a voice vote on the amendments. All those in favor signify by the normal sound of aye. Any opposed? Ayes have it. Amendments are adopted. Out to print. Back on file. And those amendments are in order because we just added an urgency. We'll move to ACR 94. Senator Calderon. I'm sorry, Assemblymember Calderon. Clerk will read.
Assembly Concurrent Resolution 94 by Assemblymember Calderon, relative to CHP Officer Joseph P. Sanders, Memorial Highway.
Mr. Speaker, you were also right the first time.
Mr. Calderon, allow me to address you first before you speak. Mr. Calderon, you may speak now.
It's okay. My memory goes back 20 years. All right, ACR 94. What it would do is it would designate a portion of State Highway Route 60 in Los Angeles and in my district as the CHP Officer Joseph P. Sanders Memorial Highway. Officer Sanders died in the line of duty while he was directing traffic during a accident on the freeway. He's survived by a wife and his 5 children, and he was known as a dedicated community person and was admired for his love of his family and his quiet and good nature. I ask for an aye vote.
Mr. Hagman.
Thank you, Mr. Speaker. Members, I just want to address, this is a wharf that we just passed not too long ago. I want to thank the author for working with our staff to make the certain amendments that we needed to have it out, and we request that the Republicans vote aye on this.
Yes, sure.
I'm wondering if we could do a roll call vote for co-authors.
Absolutely, sir. The first vote will be for roll calls. Clerk will open the roll for roll call for co-authors. Members, this is for co-authors. This is for co-authors. This is for co-authors, members. Clerk is reporting 61 co-authors. Clerk will close the roll. 61 authors. Then we'll have a voice vote on the resolution. All those in favor signify by saying aye. Aye. Any opposed? Ayes have it. Resolution is adopted. We'll move to file item 118, SB 797 by Senator Pavley. Mr. Perez will be taking this up. Clerk will read.
Senate Bill 797 by Senator Pavley and others, an act relating to product safety.
Mr. Perez.
Thank you, Mr. Speaker. I'd like to start by saying this is a simple, non-controversial bill. It wouldn't be accurate, but I'd like to start that way. I rise to present SB 797, which prohibits the sale, manufacture, or distribution of specified plastic baby products that contain bisphenol A, or BPA, a common chemical used in the production of certain plastic products that has been demonstrated to present serious health risks in children. SB 797 would go into effect only if the Department of Toxic Substance Control fails to adopt a regulatory response pursuant to the state's Green Chemistry Initiative by January 1st, 2011. Should DTSC act, then the bill will be repealed. It's important to note that this bill preserves DTSC's ultimate authority to regulate or not regulate BPA, provided that they establish their framework by January 1st, 2011. Mr. Speaker, may I ask for some order in the back of the chambers?
Members, if we could lower our conversation in the back of the chambers.
Thank you, Mr. Speaker. As many members are aware, a BPA ban was introduced by Senator Migden last year. That bill was unsuccessful in part due to the pending Green Chemistry Initiative legislation, which many members felt would adequately address the issue. With the successful passage and signing of the Green Chemistry Initiative, California established a landmark framework to approach the issues of toxic chemicals in a comprehensive and science-based fashion. Despite its efforts, DTSC has not even begun the development of formal regulatory responses. SB 797 spurs the development of these regulations by prompting DTSC to act on BPA prior to the implementation of its ban in 2011, thus enabling green chemistry to get up and running. As stated in the floor analysis, the intent of SB 797 is not to usurp DTSC's authority under the current green chemistry law. The intent instead is to preserve DTSC's ability to take a full range of regulatory responses on the chemical, on its alternatives, and on children's products as authorized under current law. At its core, SB 797 is structured in such a way to preserve the accelerated development of a green chemistry regulatory process and not to subvert it. BPA has been linked to a variety of negative health problems in children, including developmental and reproductive disorders. Like mercury and lead, BPA is a bioaccumulative toxin, which means that it's not filtered out of the system. Long-term exposure leads to increasing concentrations and negative health care outcomes. These findings have been verified by more than 220 peer-reviewed scientific studies, including a comprehensive study from the National Toxicology Program at the U.S. Department of Health and Human Services, and has been verified that BPA's harmful properties on children. Members, I truly believe that the best way to handle regulation of toxic substances is through the Green Chemistry Initiative. However, that process does not exist yet. SB 797 is consistent with the spirit and intent of green chemistry, and it will ultimately serve to ensure that green chemistry is up and running within an appropriate timeline. The science is clear. BPA-free alternatives are available, and we have a responsibility to safeguard the children of California. I respectfully ask for your aye vote.
Thank you. Dr. Hernandez. Dr. Emerson.
I will not do it. Thank you. Estoy bien. Thank you, Mr. Speaker and members. Today I rise in opposition to Senate Bill 797 as an unnecessary measure that will raise prices without improving public health. Scientific regulatory bodies such as the FDA and the Consumer Product Safety Commission have concluded that exposures to low levels of BPA do not pose a significant health risk. If this chemical is as harmful as its proponents claim, then why are companies who manufacture feeding tubes exempted from this legislation? I'd like to ask you to consider that fact. The feeding tubes are exempt from this bill. 797, as much as my good colleague stated, does abandon the green chemistry process that the legislature enacted last year to evaluate chemicals of concern. Let's use this process to determine the possible risks of this chemical rather than have the legislature implement a ban that is not based on scientific evidence. Permission to read, Mr. Speaker?
Without objection.
Thank you. This is from an op-ed on this issue that appeared in a paper in my district. The opposition has failed to explain that BPA has a 50-year safety track record, and 11 expert regulatory bodies recently confirmed that BPA is safe in food contact products. They don't tell you, the opponents don't tell you, that on July 15, the California Developmental and Reproductive Toxin Identification Committee, a panel of scientific experts, MDs and PhDs from UCLA, UC San Diego, UC Davis, and other schools in California, voted 7-0 that BPA should not be added to the Prop 65 list as a chemical known to cause cancer. Or they also omitted that in August 2008 and July 2009, Health Canada released studies of BPA in infant formula and baby foods that said the current dietary exposure to BPA through food packaging is not expected to pose a health risk in the general population, including infants and children. I ask for a no vote on this measure.
We'll go to Ms. Ma.
Thank you, members. When I was on the San Francisco Board of Supervisors back in 2006, San Francisco does have a precautionary principle, and we were able to ban both phthalates and bisphenol A. When I got here to the Assembly, I was able to pass AB 1108, which banned phthalates, which is the chemical that makes plastics softer, like in baby chew toys and rubber duckies. And 2 years ago, we heard the same argument that prices would go up, that there would be no toys on the shelves, that businesses would close. But a few months ago, we did a random test of toys. We purchased about 12 different toys from different stores, and we did a test. And you know what? There was no phthalates in any of those toys. So these types of laws work. These bans work, and it seeks to keep our kids safe. And similarly, we need to make sure that we ban bisphenol A. There are alternatives on the market. As many of you know, these Nalgene bottles are now being sold as bisphenol A free. So it's not like the manufacturers and the retailers cannot sell alternatives that are bisphenol A free. So I'm asking you, colleagues, we need to do what we can to protect our young ones, our babies, from unnecessary exposure to toxics. There are alternatives on the market. Stores will not close, prices will not increase, and there will continue to be products on the shelves. Let's do what's right for our children. Thank you, members.
Thank you. Mr. Miller.
Thank you, Mr. Speaker. I'd like to ask the members to be able to consider postponing this. I think the members voted and passed the green chemistry panel as the author indicated last year. I think the framework of the panel is up and running. This would be a good opportunity to be able to not look at all the different chemicals on a case-by-case basis, send this back, let it go back through the chemistry program, through DTSC, and utilize that resource. And I would ask for a no vote. Thank you.
Yes, Mr. DeLeon.
Thank you, Mr. Speaker. Members, I know this is a very difficult bill. When we talk about chemicals, there's always a lot of confusion, and I know there's a lot of fuzzy science around. We don't know what's true, what is not true. I will say this. I believe truly that this is a common sense measure. This is a measure for our children. Now, in speaking to members about this measure in particular, I always hear the comments that we're not scientists, so we shouldn't delve into the realm of science because we just don't know about the issue. Well, we're not engineers, and we're not firefighters, and we're not police officers. We're not mortgage bankers, and I tell you one thing, we deal with this issue day in and day out. Somehow, some way, we either regulate, we assess penalties or fines or fees on these industries to protect the public health of Californians every single day. And when we're talking about children, I think it is inherently unfair that they sell these types of products in the market today, but you have to go to Whole Foods, you have to go to Trader Joe's, you have to go to Safeway, but in low-income neighborhoods, such as the one I represent, such as the one Mr. John Paris represents, and others on this floor, they don't sell those products. So for those who have the financial wherewithal, they can afford it somehow, some way. And I will say this, that if in fact 91% of the bottles that Stimulac produces and sells on the market are BPA free. Nestle, a worldwide conglomerate, Nestle, a multi-billion-dollar corporation, 90% of the baby products, more specifically the baby bottles that they sell and they put on the market, are BPA free. There is a reason why this is happening, because the science is very clear. This is a common sense measure. This is, well, you know, this chemical and that chemical, and, you know, I'm not a scientist here, molecular structure, I don't get the DNA, what have you, etc., blah, blah, blah. It's a very common sense, simple bill. BPA is bad for children. It's that simple. And again, we're not scientists, but again, we're not police officers or firefighters. And we regulate that industry somehow, some way. And I would ask my colleagues to just give this bill an honest break, listen to the arguments for it, listen to arguments against it, read the analysis of the measure itself. Give it an honest break, because this is for our children. We're talking about the health of our children. Mr. Speaker, if you could be so kind enough, permission to read just a couple lines.
Without objection.
I'm seeing here the organizations of support, the American Red Cross, the Alliance of California Autism Organizations, Consumers Union, the Nursing Mothers Council, Physicians for Social Responsibility, and the organizations go on and on and on. Women's Foundation of California, the Zero Breast Cancer Organization, the Latino Health Access, Moms Making Our Milk Safe. I'll tell you one thing, colleagues. I surely don't want to get in between a mother and her child when it's about protecting their babies. So I would ask for you to, again, have an open mind on this measure, give it a fair shot, and I would ask for your aye vote.
Thank you. Mr. Gaines?
Thank you, Mr. Speaker and members. I rise in opposition to SB 797 and permission to read.
Without objection.
And I just thought there was an interesting quote here, but let me give you a little background. The FDA has already affirmed the safety of PBA baby bottles several times. For example, Dr. George Pauly, Director of the Division of Product Policy, stated in the May 20th, 2008 issue of Endocrine Estrogen Letter, and I quote, "Unless you can replicate something, you can't interpret its significance. Our conclusion is that we should go with a track record. We have evaluated food contact uses of BPA and in a thorough manner and concluded its use is safe. We haven't seen anything that would persuade us to change that." So I think we're really jumping ahead, and unless we have evidence that this is really creating a problem, I'm not certain as to why we're doing this and driving the cost up of products to consumers. So I urge a no vote. Thank you.
Thank you. Members, the Rules Committee will not meet until after this vote is taken up. So if members are trying to go to Rules Committee, please just know that we're not meeting until after this last measure has been taken up. All right, we'll move to Mr. Jones.
Thank you, Mr. Speaker. Members, I rise in support of this measure, which was heard exhaustively in the Assembly Health Committee. When first presented to the committee, it was a outright ban on bisphenol A. That gave me some pause. I know it gave some of the other members pause as well, given the work that this House had done under the leadership of Assemblymember Mike Feuer and Senator Samiti in the prior year on green chemistry. We developed an amendment in committee which very simply conforms the bill to the Green Chemistry Initiative by essentially placing a deadline on the Department of Toxins and Substance Control to make a determination. A deadline that gives them over a year, and their scientists over a year, to determine whether or not this particular chemical is in fact toxic to children. Now, that should be pretty simple to do, since there are over 220 studies that say it is in fact toxic. But we've given them plenty of time to reach that decision, but a deadline, because I think a deadline is important to keep everybody on track. Now, even if that deadline is met, that January 1st, 2011 ban goes into effect, even after that, DTSC can still independently conclude that regulation is not needed and supersede this legislation. So at the end of the day, what we're talking about here is a deadline and a direction to the state scientists to look at this and make a determination. And they will trump one way or the other. But I don't think we should just sit here and do nothing. That we can't afford to do in the face of the overwhelming science that indicates there is a problem. So I do think this is very consistent with where this House has been and our other House and the governor on the whole issue of letting the scientists decide. But at the same time, it makes sure that we move forward and we keep on track. I think our children deserve that, and I think it's absolutely essential that we pass this measure. I ask for your aye vote.
Thank you. Mr. Smythe.
Thank you, Mr. Speaker and members. I rise in opposition, and whenever bills like this come before this House, and I think this is the second or third year that we've had it, it's one that I pay very close attention to, because when I came to this office, I had two very small children. They're obviously still little, but I had a 9-month-old son who used these very products that this chemical was a part of. And so, obviously, as a parent, it is something that I take great care in and research very carefully. But in hearing this bill in committee and in years past, it still doesn't, the science, I believe, still has yet to catch up and confirm, what is being proposed here and the need for the bill and this chemical to be banned. And when you look at other entities, the European Union, the FDA, other state departments, our own Department of Environmental Health and Hazard Assessment, all of which have confirmed or have continued to allow bisphenol A to remain in products that are used. So for us to move forward and arbitrarily make this decision, I think is premature, because one thing that isn't addressed in the bill is what will happen with the replacement chemical. That's been discussed, and that's something that we see many times, that we ban a chemical, But then what is the replacement? And in many cases, the replacement could actually be worse because we have not had enough research. The science hasn't had enough time to study a new chemical to replace it. And that's what the Green Chemistry Initiative is about, is to give the scientists the opportunity to really evaluate whether or not we should ban a chemical, and if so, what are the alternatives and what are the impacts of those. So I think it would be prudent for us to oppose this bill like we have in years past and let the science continue to catch up. And if it does warrant a banning of this and that we have a viable alternative, then by all means move forward. But now I just believe it is still premature to do so. Have to ask for a no vote.
Thank you. Ms. Skinner.
Thank you, Mr. Speaker. Members, I rise in support of this bill. Babies, as we all know, are very little. They're very helpless creatures. They're very dependent on us. And their body weights cannot tolerate toxins to the level that we adults can tolerate. Their livers cannot process toxins. And the ingestion of even a suspected toxin can, while not present any poisonous impact to the baby at present, cause problems later in life, affect gene mutation, cell mutation, and this is the kind of thing we want to prevent. Delaying, if we delay, there are 550,000 babies born in California every year. That would be 550,000 more babies who would be exposed. If your baby was born in Canada, it would not be exposed because the products in Canada are BPA free. If your baby was in Japan, your baby would not be exposed to BPA because the products in Japan are BPA free. The EU has not had to ban BPA because it is close to impossible to find BPA-contained baby products in Europe. The manufacturers don't use it. They voluntarily eliminated it. You would have to go out of your way to find a baby bottle, a formula in a can, or a baby food in a BPA-contained product in Europe. Permission to read?
Without objection, Ms. Skinner.
Thank you. Since there was an editorial cited, I would like to cite the San Francisco Chronicle editorial of this morning. The headline is Infants versus Industry. When it comes to the science, the mass is on the side of the evidence against BPA, especially in child-oriented products. 93% of the more than 200 academic and government studies on BPA suggest a health danger, as opposed to the 11 industry-funded studies that come to a more benign conclusion. To protect our babies, I requestfully ask your aye vote.
Thank you. Mrs. Brownlee.
Thank you, Mr. Speaker and members. I rise in support of Senate Bill 797. There are numerous studies, that's a fact, there are numerous studies that support a hypothesis and a science that BPA is linked to neurological and behavioral problems like hyperactivity and learning disabilities in children. In fact, the National Toxicology Program specifically stated that they had concerns over the neurodevelopmental problems associated with the exposure of BPA. We must keep in mind that any toxin which affects neurological and behavioral aspects of our children's health not only affects their health at home, but in school. And that's why the California Teachers Association and the California PTA supports SB 797. And given that California has a rising number of children with learning disabilities and autism, there is an exponential increase in learning disabilities and autism. This is an important child safety and prevention bill that will actually save California money and save money in California's classrooms. Even if the science is inconclusive, let us err on the side of our children whose bodies are developing and are growing and are much more vulnerable to dangerous environmental exposures. This is an important bill for our children, and our children are California's future, and I ask for an aye vote on SB 797.
Thank you, Ms. Brownlee. Mr. Chesbrough.
Yes, thank you, Mr. Speaker. Members, I rise as the chair of the Environmental Safety and Toxics Committee with a perspective that I believe the committee that I chair is the guardian of the green chemistry process in our House, and hope to lend a little bit of calm and dispassionate view to what can easily become a very emotional issue with a lot of, I think, very serious arguments on both sides. When Senator Pavley brought this bill to us, she was interested in just banning this product or this chemical, and I indicated to her very strongly the committee's interest, and I think the people of California's interest in having it linked to the green chemistry process. And she wasn't happy with that because I think she came with a lot of evidence that there's a real problem with this chemical. But we convinced her. We amended the bill as it was also agreed to be amended at Health, and move forward a bill that does link it to green chemistry. And I think that's very important. And relative to the question that was raised by Mr. Smythe by my colleague from Southern California about the alternative chemicals, the green chemistry process is intended to come up with that. And this bill continues to empower the Department of Toxic Substances Control under green chemistry to continue to be directly engaged with decision-making about both the use of BPA and about its alternatives. So I think this is a reasonable bill. I think it's a bill that does not reverse the hard work and compromise on the part of many parties to put a green chemistry process together in this state. I believe the green chemistry process will go forward with integrity and not be damaged by what we're proposing to do here, and therefore I urge an aye vote.
Mr. Blumenfield.
Thank you. I rise in support of this bill. I heard a couple of comments about people citing this FDA study saying that it was safe, and I had to respond to that because that FDA study has been completely discredited. Congressman Waxman has launched an investigation because there was tampering by industry in that study, and folks are being called on the carpet on that. So I just want to make sure that nobody is relying on an FDA study when it's been discredited. On the federal level, they're talking about banning this product outright. Senator Feinstein, Congressman Markey, they have bills not just for children's product, but to just literally ban this product. So I come to this, I was actually very, skeptical about banning any particular chemical. The chemical du jour, I wasn't part of the green chemistry of process of last year, but I think it makes a lot of sense. But what this bill does, as it's been explained to me, is it doesn't force an outcome. It basically is a kick in the pants to the green chemistry process. It gives them plenty of time, 2 years from now, to come up, to look at the science and make a ruling. They could decide that this product is completely safe and take no action in that regard, and then it would preempt this ban. So inasmuch as this is a kick in the pants, I urge your aye vote. Thank you.
Thank you. Mr. Fuhrer.
Thank you very much, Mr. Speaker. I wanted to rise in part because I know a number of members have asked me what I think about this in light of the work on green chemistry last year. And let me just share a couple views. It down. First of all, those of you who, and a couple people have cited the work of OEHA when its committee declined to add bisphenol A to the Prop 65 list, I do want to point out that that is the same committee that took until 2006 to name secondhand smoke an item that would be toxic on the Prop 65 list. 2006. I'm not sure that the work of that committee should be dispositive of anything we do on this floor. And now, with respect to the interplay between the Green Chemistry Initiative and this bill, many speakers have been either chairing committees that have overseen this bill or otherwise worked on this bill as it's gone through the process. And the core point that they've made that I want to emphasize is this. Originally, this bill was an outright ban. I think an outright ban of bisphenol A with nothing else would have been in conflict with the Green Chemistry Initiative and cause problems for us because of the precedent that would set. That is not this bill. This bill does create the following rule. January 1, 2011, the action takes effect. By the way, again, no matter what other action DTSC takes, either before that date or after that date, if DTSC's action is in any respect different from the action that this bill would direct, DTSC's action is that which takes effect, and this bill is nullified. Obviously, if DTSC decides to act to ban or simply exceeds to what this bill does, then the bill stays in effect. But any other result from DTSC is the result that governs. That is consistent with the green chemistry approach. I think, in fact, it's compelled by the green chemistry approach. So we have a couple choices here. People have suggested ways that they might find to fine-tune this legislation in some way. This bill has gone through an evolution that's seen multiple changes to this bill. Where we are now, I think, is a place where those of us who promoted the Green Chemistry Initiative and others concerned about making science-based decisions here can safely land. So I'm going to urge an aye vote of this bill today. I think this bill is a moderate bill that nonetheless accomplishes a very important goal. Therefore, it should find common ground across the aisle, and I urge an aye vote.
Thank you. Mr. Blakesley.
Thank you, Madam Speaker. Members, obviously with term limits, we don't have the institutional memory we once had. But I'm a little disheartened because what we're referring to is an agreement that was made just last year. On this floor, I stood up and supported AB 1879 as the only Republican because I believed last year that if we worked together collegially and could reach across the aisle and agree that if we designed a green chemistry system that worked, we could put an end to the type of bills that I am seeing on the floor today. I may be the only scientist or former scientist who serves in the legislature right now, and of course I've listened with great interest as different members have talked about different studies. And of course, having spent many years making my living either performing those studies or debunking different studies, I'm very aware of how difficult that process is to do with certainty, which is exactly why we established a green chemistry process, so that we could defer to professionals and make sure we had a rigorous environment in which these very important issues could be adjudicated. So I'm not standing here to try and argue for the chemical or against the chemical. I'm trying to argue for maintaining the integrity of our agreements. Because although one could imagine a bill like this somehow getting past this legislative body despite the agreements we had, and it presumably would not fare well on the governor's desk, think about what that does for future such agreements that we may seek to forge on a bipartisan basis, and what message does that send when you ask one Republican to stand with you and try and solve a problem which has historically never had bipartisan agreement. The course you take today on this vote is much larger than this particular chemical or this particular bill. It speaks to the question of whether or not we can make agreements across the aisle and whether or not those agreements will hold up. We're all watching. I respectfully ask that you either vote no or lay off, at least in respect for the process, so we can continue to work in a bipartisan manner.
Thank you. Mr. Solario.
Thank you, Mr. Speaker and members. I, too, last year co-authored the Green Chemistry Bill, and I did that so we can avoid debates just like this. The reality is there are studies on both sides. Other than our Republican leader, none of us are scientists. There's debate amongst countries as to whether this is a good approach or not. I would tell you that back to term limits, there was a mention that Senator Migden had this bill last year. Well, you know what? This is actually the 6th time that this body looks at this ban the 6th time. You know, we also lose that there are debates about, whether BPA-free and some bottles or chemicals are truly that. You know, I know it was mentioned Similac and Nestle. Well, you know what? Those companies assert, these are the companies that make these products, they do not meet the threshold of this bill. And we're not scientists to know, do we ban, do we not, are there alternatives, how much time do they need? You know, but finally, just in conclusion, I would say that the Green Chemistry Initiative, as was mentioned by another speaker, would have a different approach on this. This approach we would take today via this bill prejudges an outcome. I know one of my colleagues says this would not force an outcome. This would. I would say that let's leave this to the scientists. Let's send the message. We don't want to every year be looking at chemical bill bans. Let's have our scientists look at this. They know best. Thank you.
Thank you. Ms. Saldana.
Thank you, Mr. Speaker. Members, the scientists have looked at this. The scientists in Canada have looked at this. They are getting rid of this in children's products. And ask any teacher what they are seeing in their classroom these days, and you will see very clearly that children are developing differently than they did a generation ago. That the learning disorders, that the disabilities, that the special needs students in our classrooms are growing at the same rate that we see the chemicals in our products growing. Now, I've done a lot of work on hazardous waste. I've talked to a lot of people that are looking at what we are putting into our electronic products, into our consumer products, into our water as a result of that. And the evidence is very clear. And if we want to wait and delay and let others take the lead on this, then, as I've said many times before, when we look back from the comfort of 5 or 10 or 20 years and we see what we could have done under what is now called the precautionary principle, which is basically, let's take an action to avoid the harm. Let's be cautious. Let's act and keep the analysis going and keep the research going. But I will tell you, as an educator, dealing with not just young children, but adults with learning disabilities and trying to figure out why. Why are we seeing these health problems? Why are we seeing these developmental problems? Why are we seeing people struggling when they should be thriving? If we can do one thing to take away those risk factors, then we need to do that. And in answer to some of the questions, well, why isn't it banned in things like feeding tubes? Well,
members, can you lower your voices on the floor, please?
Thank you, Mr. Speaker.
Members, lower your voices on the floor.
Why is it not being banned in certain products? Well, we understand why. Whenever we work on these bills, we look for areas of agreement. There is a process to come to a consensus. And if we can give up something like a feeding tube, which is typically used in adults, not in developing children, then we will do that to remove some opposition, to come to a consensus. That is part of the process. That is part of what has been done with this bill and many other bills. For those who say this is not reasonable, I say what is unreasonable is to let our children potentially be poisoned.
Ms. Saldana, 1 second. Members and senators, please lower your voices on the floor.
The hour is late. We will be taking a recess soon. But I will just say I would support this bill. I encourage those of you that may be considering whether or not to support it, please do so. The precautionary principle is very simple. If we can take actions to avoid harming others, we do it. We've come to this job to make some difficult choices. It's what our constituents want us to do. And when it comes to the health and safety of our children, difficult choices are worth taking. I ask for your aye vote.
Thank you. Mr. Davis.
Mr. Speaker and members of the Assembly, we have before us a bill that really tears at some of the challenges we have in California today. The concern that we have an environment where we're not running businesses out of town, making sure that we make decisions that at least that there are alternatives when businesses are called to the attention of some of the harm that products that they potentially might have will cause. And the question today is, has there been any scientific evidence? My colleague, the gentlewoman from Santa Monica, stated that there clearly have been studies that have explored the potential concerns that we should have about bisphenol A. In Europe, there's a theory that is quite different than the model we use, innocence until proven guilty. You're kind of guilty until proven innocent. And if, in fact, we should flip that concept, we should certainly flip it today. And you would probably ask the question, why? I think in many ways, the reasons why have been discussed from the many colleagues on the floor. But in particular, it was mentioned that biologically children don't have the same sustainability in terms of substances that adults have. That is probably an underscore of my concern as to why I rise, because I'm not a scientist. Many of us are not scientists. But one or two things that I am that's going to matter today is the fact that, one, I'm a member of the Environmental Safety and Toxic Materials Committee. And the second thing that I am is going to matter is that I'm an assemblyman, and I have a finger and I can push the green button. And I think that today, in conclusion, it is important for those of us, all 79 of us, to be able to push the green button because there is a question. And when we're dealing with our children, we want to ensure that there are not any questions that hamper their growth and development. I've heard too many questions today, and I am certainly not a legislator who will threaten businesses and their ability to stay in our state. But yet at the same time, I'm not going to cut off my nose to spite my face in terms of the safety of our children. And from what I have heard today, I am concerned about the questions on bisphenol A. I'm concerned because Nestle has, without these so-called conclusive studies, seen the need to ban bisphenol A. And so, if Nestle wanted to take those very important steps, I think it is incumbent upon us today to make a decision on behalf of children. There are many alternatives that could be available. And let me just say that one of the things that also was disturbing was the statement that bisphenol had substances seeping out of it when people looked carefully at it. And so let me just simply conclude that as legislators, we can't be all things. We come from different fields of human endeavor. But sometimes science can't outweigh common sense. There are too many questions for us to make a decision about substances that our children will digest or consume in some way because of a product that they're taking. And so with that, ladies and gentlemen, I ask you from the School of Social Science to take a very good look and vote for this bill because it will help to protect our children. Thank you very much.
Mr. Portantino. Mr. Fruitani.
Mr. Speaker, that's no problem, sir.
My apologies.
No problem. You've been doing a great job running the floor. A mispronunciation of a name or making me Italian, that works for me. You know, there's been a lot of passionate statements made on the floor relative to this important bill. This is the second time I've personally seen it. Last time I was absolutely supportive of the Green Chemistry Council. Although differing opinions, there's one thing that seems to have rung very true for everybody that's spoken on the floor, and that's the importance of this Green Chemistry Council. Whichever you're going to vote, that will remain to be seen. But what I challenge everybody here that's spoken on the floor and everybody that's going to vote on this bill, like I have and other people, there's 4 of us that have signed a letter that we've already sent to the Green Chemistry Council. I know Mr. Fuhr has and others as well. I suggest all of us demand in a letter to the council that they immediately take up this issue and not wait any longer or delay any longer so we can get results on this before the deadline that's been established by this bill, which is January 2011. So let's everybody, as elected members of the legislature, send a letter or make a call to the powers that be relative to the Green Chemistry Council. Say, stop dilly-dallying, stop delaying meetings, get this done now.
Mr. Pettis, you may close.
Thank you, Mr. Speaker. Members, this was not a bill that I came to easily. I have been one that's been critical of us trying to individually regulate a variety of chemicals. I have been one that believes that we should defer to the green chemistry process. I'm heartened by the statement of my colleague encouraging us to send a clear message to the Green Chemistry Council to take action. I, like he, am willing to send that letter. But we're not just anybody. We're the legislature. We have an ability to do something even stronger, and that is to force them to take action immediately. The way we do that is by passing this measure. This measure only has practical effect if they fail to act. This is the greatest call for urgency in the action of the Green Chemistry Council that we can offer them. It is suggesting that they take their responsibility seriously and act immediately to evaluate the science. There have been several statements made on the floor in opposition to this measure that I'd like to speak to. The first was with respect to whether or not this ban would increase the cost of products. And it's clearly not the case. What this does is direct us to have universal access to products that are free of BPA throughout the state, so that there isn't this unequal access to BPA that we currently exist. If this were to drive costs up, we wouldn't see the marketplace responding the way that it is. Right now we see Nestle, Gerber, and Similac all having BPA-free packaging in their products, even though some of their competition doesn't. If it drove up their cost, if it drove up the cost to the consumers, that would have put them in a competitive disadvantage that wouldn't allow them to move forward in that way. So we know that that argument is not necessarily an argument that holds water. We also know that we're not alone in addressing this issue. Connecticut, Minnesota, and Massachusetts have all instituted BPA bans, and the formula industry was able to respond, and 18 other states are looking at this. Additionally, opponents have offered a handful of scientific studies that they claim discredit BPA's harmful effects. These studies were in many cases financed by the manufacturing industries and have been unequivocally refuted by more than 220 independent, peer-reviewed scientific studies, including one comprehensive study by the National Toxicology Program, which verified the health concerns with BPA. That's what the scientific community is saying, not uniformly. You don't get uniformity in the scientific community, just like you don't get uniformity in a legislative body. But the preponderance of the results of the studies is that there is absolute problems associated with BPA. And for us to look at a few outliers and use that as an excuse not to act is irresponsible. The most responsible thing we can do is to support this measure and to spur DTSC and the Green Chemistry Council to action. I respectfully ask for an aye vote.
Thank you, Mr. Pettis. All debate having ceased, clerk will open the roll. All those vote who desire to vote. 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 Mr. Pettis moves the call. Is Mr. Tirico on the floor? Without objection, we recess the regular session and convene the third extraordinary session, and we'll substitute the prayer and pledge in the order of business. We'll move to Mr. Tirico for motions and resolutions. Mr. Tirico.
Thank you, Mr. Speaker. I request unanimous consent to refer AB 81 by yourself to the Arts and Entertainment Committee and the Appropriations Committee immediately.
Without objection. Mr. Tirico.
Mr. Speaker, by way of announcement, I want to make sure all the members are aware of our schedule for the next 90 minutes.
Let me just bring order to the House, Mr. Tirico. Do you have any more business in the special session?
Semi-related.
Okay. Very well. Let's bring order. Can we bring members? It's been a long day, and we are trying to get all the members out of here as soon as possible. We have about another hour and a half worth of business, but it can go longer if we do not have the attention of all the members in the House. Please focus your attention at this time to Mr. Tirico.
Thank you, Mr. Speaker. The following is our schedule for the next 90 minutes or so. The Rules Committee room is meeting immediately on the confirmation of Mr. Horton for the Board of Equalization. That is happening in the Rules Committee room immediately. At 5:45, the Utilities and Commerce Committee will be in room 437. 5:45, Utilities and Commerce in room 437. At the same time, 5:45, the Governmental Organization Committee will meet in room 4202. At 6:15, the Arts and Entertainment Committee will meet in room 447. And at 6:45, the Appropriations Committee will meet in room 444. We will come back to the floor at 7 o'clock to lift calls and to adjourn for the evening. A prompt return to the floor by all the members at 7 o'clock will be greatly appreciated. Otherwise, the bills will remain on call until we have sufficient members to lift the calls and to finish our business for the day. Please return to the chambers at 7 o'clock. Thank you.
Mr. Tirico, we will recess under call. We are recessing under call. All members are required to stay within. You are allowed to go to your offices, but you're not allowed to leave the building. We are recessing under call. We'll convene at 6 p.m., 7 p.m. promptly. The House will be in recess. Recess under call.